front if you possibly can. That's a big help. We appreciate that. My name's Susan Alcorn, and I'm the coordinator for today's forum. And I want to welcome all of you here to the First Unitarian Church of Cleveland. The title for today's forum is the intersection of abortion, the Supreme Court, and states' rights. Given the importance of this subject, we hope to challenge you with new thoughts and perspectives on this issue that you'll continue to think about and perhaps even act on. We have a mission in this church to search and to serve. We believe in the continuing search for truth and the importance of serving others. We organize these forums as a congregational service to the community to support personal reflection, social action, and individual and collective growth for all who attend. We chose today's topic for discussion because a woman's right to reproductive choice continues to be a contentious and divisive issue. Discussions on the moral, legal, and political issues surrounding reproductive choice predate the Supreme Court's 1973 Roe v. Wade decision. As we begin the discussion of a deeply personal decision that 1 in 4 women will make in their lifetime, the decision to have an abortion. We want to express our sincere appreciation to the League of Women Voters of Greater Cleveland for co-sponsoring this forum. Mary Levin Butler, co-chair of the Shaker Heights chapter of the League of Women Voters of Greater Cleveland, will now introduce our speaker. She has also been general counsel for the San Jose Planned Parenthood Center, the largest one in the country.
Thank you, Susan, and thanks to all of you for being here this morning. On behalf of the League of Women Voters Greater Cleveland and the Shaker chapter, since we're sitting in Shaker, thank you. We are honored to be co-sponsoring this event this morning on such a critical and timely topic. But more important, we are thrilled to have Professor Hill here with us today. She is an amazing woman, a brilliant lawyer, and we are so fortunate to have her. I'm going to embarrass her to heck, but that's okay. We are so fortunate to have her here in Cleveland and working on behalf of women across the United States. Let me just give you a little bit of a background on her. She's the Associate Dean for Academic Affairs at the Law School of Case Western Reserve. And of course, as it notes there, she is the Judge Ben C. Green Professor of Law. Professor Hill went to Harvard Law, Brown undergrad, and her area of expertise is constitutional law, law and religion, and most important for this morning, reproductive rights. She joined the faculty in 2003 after practicing constitutional law and First Amendment law here in Cleveland. Before that, she worked at the Center at the Reproductive Rights Project for the ACLU in New York City. There's somebody else that we know in the law who was at the Reproductive Rights Center, the notorious RBG. That's where she was as well many, many years ago. Professor Hill is working diligently, tirelessly, daily on challenges to reproductive rights on the state level. And that is really critical. The map that you all sent out along with the invite was so telling if you looked at it, because it looked at the different states around the country in terms of the status of abortion in the event Roe is not completely overturned, but basically gutted. It goes back to the states. And for us in Ohio, that is really, really scary because there have been so many basically chips and cuts away at this right. So without further ado, because you don't want to listen to me this morning, I am thrilled to introduce Professor Jessie Hill.
Thank
you, Mary, for that nice, very nice introduction. Sure woke me up this morning, this Sunday morning. Can everybody hear me okay? Yeah. Okay, so I should stay here and talk, right? Because it's, okay, great. And thanks for Sue for inviting me to speak here. I think I've spoken here once before. It's always a really great experience. I find that we have a wonderful dialogues here. So yeah, as Mary said, I work on this issue. This is really my specialty within constitutional law is reproductive freedom and reproductive rights. And I also continue to practice as a litigator in this area, so challenging state laws that restrict reproductive freedom, of which there's been plenty going on in Ohio to keep me busy. So I want to give a little bit of an overview from the legal perspective of where things stand today, and then what the potentially very near future might hold with changes in the Supreme Court. And then I'll be sure to leave plenty of time for Q&A after that. But first, I want to just give some sort of general background on abortion, some basic statistics. This is from the Alan Guttmacher Institute, which is a research organization. There are about a little less than 1 million abortions a year in the U.S. About 3 in 10 women will have an abortion by the age of 45. Yeah, I guess the number keeps as this notes, the number keeps dropping actually. So it's about 1 in 4 right now. Almost 50% of abortions, of pregnancies in the United States are unintended, and nearly 40% of those end in abortion. Almost 60% of women who have abortions already have at least one child. 91% of abortions are in the first trimester, so the overwhelming majority, that the first trimester is the first 13 weeks of pregnancy. Only about 1% occur after 20 weeks of pregnancy, the halfway point. 90% of U.S. counties right now are without an abortion provider. And abortion rates are falling, as I just said. They have been falling for several years now. They are currently the lowest since Roe v. Wade. Abortion is, as I'll talk about, regulated by the Constitution in the sense that the Supreme Court has made the right to terminate a pregnancy a constitutional right. But then there is room for legislation on this topic as well, and most of that legislation regulating, not outlawing, but regulating abortion has occurred at the state level, and at the state level those laws vary quite a bit. Of course, if the Constitution conflicts with a state law, if a state runs afoul of what the Supreme Court has said, the Constitution trumps and the state law has to be struck down. Okay, so this, it sounds like maybe you've seen this map before, and I know you can't read it from where you're sitting, but this is a map that kind of gives you the outline of where the states stand with respect to abortion. The blue states, or bluish, it looks bluish-greenish on this, are supportive of abortion rights. The yellow states are hostile, and the orange, well, looks red, states are extremely hostile. And then the other states are kind of middle ground in between states, a little of both. So there's only 12 states on this map that can be considered supportive of abortion rights right now, and 29 that are hostile or extremely hostile. In 2017, that red is not showing up very well, I apologize. 19 states enacted 63 new abortion restrictions. So some states at the same time did expand access both to abortion and to contraception in 2017. However, the overwhelming trend has been toward restricting access. And between 2010 and 2016, there were almost 397 abortion restrictions passed in the states, which is about a third of all the restrictions, all the laws restricting abortion that have been passed in the 45 years since Roe. We're just in this 6-year period. So this is an area where it is very timely because there has been just a dramatic amount of activity on the state level in terms of laws passed regulating, restricting access to abortion. Here's another sort of visualization of that. Again, from 2011 to 2016, to show you, this shows you each year, starting with 1973, how many restrictions have been passed. You can see the huge uptick. Okay, so in Ohio, what's going on in Ohio? Well, depending on how you count it, it's about 20 laws passed since 2010 in Ohio restricting abortion rights, reproductive rights. In 1999, there were 22 clinics providing surgical abortions in Ohio. Today, there are only 7. So I think this postcard's funny. I don't know if you can read it. It says, "Greetings from Ohio. Hope you're not a woman." And then it has the number of clinics in each city, which actually is not even accurate anymore. So it's from like about a year ago. So there's 1 surgical clinic in Cincinnati, 1 in Dayton, 1 in Columbus, 1 in Akron, 2 in Cleveland, and 1 in Toledo right now. So a total of 7. I should note there are some clinics that provide medication-only abortion. So you can have an abortion not with a surgical method, but with just taking pills up until 10 weeks of pregnancy, so very early in pregnancy. And there are 3 of those clinics that provide medication only in the state. Cincinnati is, with 1 clinic left, is poised to become the largest metro area in the country without an abortion provider. And I say that partly because they're down to 1 clinic, but also because that 1 clinic, along with the 1 in Dayton, they're both in constant jeopardy of losing their licenses to operate. That's because they cannot meet the legal requirements for operating, and under some recent laws that have been passed in Ohio, clinics have to have something called a written transfer agreement with a hospital, which is an agreement with a hospital that says you'll transfer patients there if there's any kind of medical emergency. And it's a very short, it's like a 1-2 page document usually. A law recently passed in Ohio says you cannot have that agreement with a public hospital. The public hospitals are not permitted to enter into those agreements with abortion providers. And this sounds like not a very big deal. What's the big deal about getting this contract with a hospital? Well, it turns out in Cincinnati and Dayton, there are no hospitals that are willing to provide one of these agreements to an abortion clinic. So Planned Parenthood in Cincinnati and then an independent clinic in Dayton cannot get these agreements with local hospitals partly because in Cincinnati, almost every hospital, in particular in Cincinnati, every hospital except 1 is either Catholic or public. And Catholic hospitals will not enter into these either. Even the Jewish hospital is Catholic in Cincinnati, believe it or not. So it's a real problem, and these are actually really, I just want to take a minute to say, these are really unnecessary requirements because in fact, if you are having a medical emergency, no hospital can turn you away. It doesn't need to have an agreement with your clinic in order to admit you or to stabilize you or to treat you. And in fact, the other issue is that it has to be with a local hospital within 30 miles of the clinic. And with access shrinking and shrinking and shrinking, in Ohio, women are traveling longer and longer distances. Chances are, if you are having a problem after having an abortion procedure, it's probably going to happen after you've gone home, and you're probably going to go to your local nearest, hospital or ER anyway. So it's a really pointless requirement that has been incredibly effective at closing clinics in Ohio. So the ones in Cincinnati and Dayton are working on what are called variances, where every year they have to go to the Department of Health and ask them if they can stay open anyway, even though they can't meet this requirement. They have to find another way to ensure to the satisfaction of the Department of Health that they are able to get patients treated if necessary. They basically have to have doctors who are willing to serve as backup doctors who can admit patients. Which is also a whole other story because in some of these areas in Dayton and Columbus in particular, there have been campaigns by anti-abortion groups to expose the names of these doctors, to picket in front of their homes, and they've been sent letters threatening to sort of make their lives miserable if they agree to sign these agreements. So a very difficult situation. Okay. So just some legal background here. You are probably familiar with Roe v. Wade, the 1973 case that said that women that the right to choose an abortion, to terminate a pregnancy, is an aspect of the liberty that's protected by the Due Process Clause of the 14th Amendment. So the 14th Amendment to the U.S. Constitution said that no state can deprive any person of life, liberty, or property without due process of law. And it's really in that liberty term that we find the right to end a pregnancy, to choose whether to become a parent or not, which includes also the right to choose contraception. And that's what's often referred to as the fundamental right to privacy as well. So we talk about it as a privacy right, but the language hook in the Constitution is liberty. The Supreme Court also in Roe laid out two things, two other rules. One was that there was this trimester framework for regulating abortion where the amount that states could regulate the procedure, so nobody can ban it, but if you can regulate it more and more depending on which trimester of pregnancy you are regulating. And then also that there was something called strict scrutiny for any law that regulated abortion, which means that courts will look at those laws really, really carefully and make sure that they are necessary, that they actually are serving an important government purpose. You can't just pass anything and sort of say, well, we just thought it would be helpful to have this kind of restriction on abortion, like written transfer agreement requirement or something. There has to be a really good reason for it. However, those two requirements have gone away since then because of some ways in which Roe was superseded by a 1992 case called Planned Parenthood v. Casey. So in 1992, the Supreme Court revisited abortion in a really kind of fundamental way, and I don't know how many of you remember this case or hearing about it at the time. I was in college, I was a senior in college, and I remember everybody talking then about how this might be the case that overturns Roe v. Wade. It was fully expected because of the way the court had changed. The Supreme Court justices had changed since Roe. Nonetheless, this 5-4 ruling with a joint opinion by justices, and again that red's not showing up, but that says Kennedy, O'Connor, and Souter, who wrote the opinion. Oh, that's better, huh? Who wrote the opinion upholding still the fundamental right to terminate a pregnancy. So Kennedy, obviously, I highlighted him because this is a key point, that he was one of that three-justice plurality. And those were actually all three justices, Kennedy, O'Connor, and Souter, were all three Republican appointees, appointed by Republican presidents. So the court held that the right to privacy remains protected by the Constitution, but there was a new standard. We got rid of that trimester framework, and the court said, and we got rid of that strict scrutiny idea that you have to look really carefully at these laws, and just said, as long as the law does not impose what it called an undue burden on abortion access before viability being the point at which the fetus, if it were delivered, could survive on its own outside of the woman. Before that point, laws are constitutional as long as they do not create an undue burden on the woman wishing to decide to terminate a pregnancy. What does that mean? We have been trying to figure it out ever since. It's a very sort of unclear standard, which has been part of the problem, legal standard, that courts have kind of interpreted in various ways, and it's really encouraged states to sort of push the envelope, try different ways of restricting abortion. In Planned Parenthood v. Casey, the court upheld a lot of laws that it had struck down in the past, including a waiting period with a 2-trip requirement, so the woman has to go 24 hours ahead of time for informed consent counseling and then go back a second time for her abortion procedure. Parental notice for women under 18, reporting and record-keeping requirements, but struck down, the only thing it struck down was a spousal notice requirement. And then finally, this is still a recent memory, 2 years ago, in the case of Whole Woman's Health v. Hellerstedt, again, if you sort of follow this thing, it was in the news very much. where clinics and doctors challenged this Texas law that had two requirements. One was that physicians who perform abortions have to have admitting privileges at a local hospital. This functions a lot like the written transfer agreement requirement I was talking about before, in that hospitals don't have to give you admitting privileges. They usually don't unless you're on staff, and so it can be very hard to meet and results in clinics shutting down if they have to meet this requirement. And also a second requirement that clinics had to conform to these laws or regulations for what are called ambulatory surgical centers, which are kind of mini hospitals. You've probably been to these before. They're those kind of outpatient hospitals, right, where you can get like a colonoscopy or a minor plastic surgery. I don't know, maybe LASIK. I don't know, those kinds of things. But there are certain restrictions on how they're built that can be very expensive to conform to, especially if the clinic has been around for a while, and they were not able to get grandfathered kind of into that. So the law in Texas would have closed 32 of Texas's 40 clinics. The first requirement, the admitting privileges requirement, actually went into effect and immediately closed half the clinics. So Texas went from 40 to 20 clinics immediately. If the second requirement went into effect, it would have brought them down to 8 clinics. Women in rural areas, as you know, Texas is a pretty big state. We're going to have to travel hundreds of miles each way to access an abortion. And the court found in that case, in what was considered a big victory for abortion rights, that the Texas law imposed an undue burden on the abortion right, because basically these requirements had no actual health or safety benefits at all, although that was the purported reason for them. But it, oh, am I getting hard to hear? Okay, sorry. Can you hear me back there? Is that better? That's better. Oh, yeah. Okay, so the court found that this law was unconstitutional because these requirements had no actual health and safety benefits, although they imposed a huge burden on abortion access in the state, right, closing 3/4 of the clinics. And the court said in that case also, part of why this was seen as such a huge victory was they said you have to actually look at the evidence. That is there evidence to say that these requirements are necessary or that they are serving the purposes that the state says they're serving? Courts weren't always doing that before. This was a 5-3 decision. This was decided during the period where there was a vacancy and Justice Scalia had died and had not yet been replaced. So he would have been, had he been on the court, he would have been the 4th vote against this holding. He would have been in favor of upholding the law almost unquestionably. So Justice Kennedy, of course, was an important sort of 5th vote here in this 5-3 decision. Okay, so, well, I'm going to skip to say now what happens if Roe is overruled in the future, and I'll talk a little bit right after this about what we can expect with the new appointment of Justice Cavanaugh on the U.S. Supreme Court. There are kind of the how abortion might be, Roe might be overruled is important. So one possibility is that the court says that fetuses have a right to life. That they are persons under the 14th Amendment, that language I showed you, the due process clause, and that you can't deprive them of life without due process. Honestly, this is the least likely scenario. No justice, even Justice Scalia, who was probably the most fervently anti-abortion justice on the court, no justice has ever taken that position. It would be very complicated. It would mean that you couldn't allow abortion under any circumstances, even to save the life of a woman. So no one really, no jurists have taken this extreme view. So it's unlikely. The more likely is one of the other two scenarios. So either that abortion is no longer a constitutional right, oops, there's a little typo there, and that it's up to the states to decide how they want to regulate it. So you can't really challenge restrictions. It's just sort of a state law matter. Courts are going to kind of try to be out of the business altogether. States can regulate it or ban it however they want. Or the third is that there would be a narrow interpretation of undue burden. So kind of keeping that standard that we've had since Casey and in the Texas case, Whole Woman's Health, but interpreting the legal standard much more narrowly to not be very protective of women's rights. That's also a likely scenario. So, where are things going, and is this likely to happen? Well, let's talk a little bit, just briefly, about what we know about Justice Kavanaugh. This is an article from the New York Times, actually on Friday. We're talking about how abortion rights groups are starting to prepare for possibly a world after Roe, and thinking about what this might look like. What we know about Justice Kavanaugh is that he is a justice who considers himself an originalist and a textualist. This is very much in the model of the late Justice Scalia. Most folks who subscribe to those schools of thought do not find a right to abortion in the Constitution. He, in a speech from a few years ago, mentioned how he agreed with Justice, the late Chief Justice Rehnquist's dissent in Roe v. Wade, where Justice Rehnquist was one of two dissenters in that case. Roe was 7-2, by the way. So was one of two dissenters in that case, saying there should not be a constitutional right to abortion. Justice Kavanaugh, he doesn't have a huge record on this issue from when he was a judge on the D.C. Circuit, and a lot of folks don't really understand, or this doesn't get talked about a lot, but the D.C. Circuit, where Justice Kavanaugh was a judge before ascending to the Supreme Court, is a circuit that tends to have a kind of unique docket. The kinds of cases that it hears are unusual compared to other parts of the country. So it only has jurisdiction over D.C. And unlike other courts of appeals that have jurisdiction over, a few states, federal courts of appeals. And it's mostly administrative law. It's mostly deciding issues pertaining to what federal agencies are doing. That's a huge part of what those judges do. A very small part of it is this kind of thing, is abortion rights, any kind of, labor law, employment law, the kinds of things, criminal law, the kinds of things that are on the dockets of other kinds of appeals court judges. So we don't. However, he did famously rule against Jane Doe, the undocumented immigrant minor who was seeking an abortion while she was in state custody. You may have heard about that case. And in his opinion, he said that there's no right to an abortion on demand, and that it would not be an undue burden on Jane Doe to wait a few weeks until they could place her with a family to help facilitate her abortion. She was already about 15 weeks pregnant at the time. Okay, so here's that map again. What happens if Justice Kavanaugh votes that abortion should return to the states? 13 cases are currently pending in the federal courts of appeals that could lead to overturning Roe. Again, this is something that I don't think has been quite in the news enough. We don't have to have a state just ban abortion outright and then wait for that case to make its way up to the Supreme Court. There are 13 cases that are sitting one step away from the Supreme Court right now, that if the Supreme Court takes them, could use them, any one of them, to overturn Roe. They're just challenges to various kinds of abortion restrictions. As a matter of fact, Indiana passed a law forbidding abortion if the fetus if a reason for the abortion, the reason for the abortion is that the fetus has an anomaly. Except with an exception for lethal anomalies. But if there's like Down syndrome, like other sorts of anomalies that might be a reason why somebody would choose to terminate a pregnancy, Indiana made that illegal. The court struck it down. The appeals court struck it down. Indiana just last week filed a petition asking the Supreme Court to take that case. And Ohio had passed actually a very similar law banning abortion for reasons of Down syndrome that has been struck down by the federal court here, but is very similar. So that could affect Ohio's law as well if the Supreme Court takes the case. The Supreme Court doesn't have to take a case. It can decide whether to or not to, but we'll likely see a patchwork of state regulation. That's why I put that map back up there. 9 states have pre-Roe bans on the books still. They've never repealed them. They just don't enforce them. So if Roe v. Wade is overturned or the right to abortion is overturned, they could try to just start enforcing those bans right away, the next day. 4 states have what are called trigger laws that say if Roe is overturned, we will start criminalizing abortion. Ohio is not actually in either of those categories. Ohio does have a law that says, though, that it's the policy of the state to favor childbirth over abortion to the extent constitutionally permissible. So it's not really a law that has any legal effect, but it does indicate which way Ohio is likely to go. Finally, 21 states are considered more protective of abortion rights, if likely to protect abortion rights if Roe is overturned. Going forward, one thing is that state courts might play a more important role. If the Supreme Court gets out of the business of overturning restrictions on abortion rights, some states, they'll be able to look to their state courts to protect them. So, for example, in Iowa, which is in the hostile camp, the yellow one right in the middle there, their Supreme Court has actually proved to be very protective of abortion rights. So it recently struck down a 72-hour waiting period law for abortion over the summer that the legislature had passed. That legislature also passed a heartbeat bill banning abortion as soon as the heartbeat is detectable, that the courts have struck down, the state courts. So that's kind of where things stand. I mean, I'll stop there because I've been talking long enough, I think, and I want to give a chance for Q&A, and I just wanted to give, like I said, the big legal background, and I'm happy to talk more about anything folks found to be of interest. So thank you for your attention.
All right, it's now time for questions and answers. And I want to mention a few things here. I'm going to pass these clipboards around, and if you want to receive a reminder of the upcoming weekly forum, sign it if you're not already a part of it, and you'll get things like the map that she talked about with background information on the subject. I want to also mention that our Q&A has a couple rules here. One is that those holding the microphones are the ones that choose the people that will be making the question. We want to ask you to hold the microphone very close to your mouth so we can hear the question, and please keep your question short. No speeches, please. Thank you.
I'm a dedicated financial supporter of Preterm. What is their situation?
Well, so in some ways, Preterm, which is, I don't know, folks know, is an abortion clinic here in Cleveland, right near Shaker Square, kind of, where, and I'm also on the board, actually, of Preterm. So it's a nonprofit abortion clinic that has been around since Roe v. Wade, basically. And also is kind of been very on the forefront of the reproductive justice movement, which I could also say more about. But Preterm is one of the more stable clinics in Ohio, in Cleveland. So we have Preterm, and then we have Planned Parenthood in Cleveland. And because this part of Ohio, I guess, is a little more supportive of reproductive rights, they have not had a problem, for example, getting a written transfer agreement with a hospital. They've had a little bit of an easier time on that front. And a lot of, as the clinics close, you know, the Preterm's kind of able to pick up some of their slack, fortunately. But, I mean, that being said, I don't think anyone in the state feels very comfortable. No one feels secure. It's, you know, there are these constant assaults, legislative assaults, you know, still constant hostility of protesters. Preterm has been vandalized repeatedly in the past couple of years. You know, by someone that they haven't been able to track down yet. So there's a lot of, you know, they're still very embattled, like all of the providers in the state. But I would say, you know, both sort of from a financial perspective, a legal perspective, they're on firmer ground than a lot of places. But they do need your support, absolutely. So don't let your foot off the pedal.
No, I never will.
Yeah. Good.
Thank you, Professor Hill. I want to go back to the church's mission, which is search and serve, to ask you what kind of action we can do. What's really bizarre is that there's such a disconnect between the laws that are being passed, the decisions of the court, and what the majority of American people support a woman's right to choose. So we know we cannot elect federal court judges, and the pro-life, and I use the term loosely, the pro-life in utero movement is so powerful that it's such a single issue for electing public officials. Even dog catchers are asked. Dog warden candidates are asked if they're pro-life. So what can people actually do to stem this legislative and judicial tide that is totally gutting Roe versus Wade?
Yeah.
What can we do?
Right. It's, you know, if there were an easy answer, right, I wouldn't probably be here right now, but I think, well, right, and you're right, you know, a recent Pew poll, for example, showed that 70% of Americans support Roe v. Wade, you know, 2 to 1, right? And I don't think in Ohio, I mean, in Ohio, the numbers are not that different. It's still a majority of Ohioans support the right to abortion under at least, you know, most circumstances. You know, certainly voting, that's right, but not just voting on federal judges, but in Ohio, it's incredibly important. Right now, we have a Supreme Court that is, you know, all Republicans, essentially, an Ohio Supreme Court. Where, yeah, it's extremely hostile to reproductive rights. So, you know, pay attention. There are two vacancies. If you have your absentee ballots or whatever, right? Pay attention to who you're voting for, because there are 2 vacancies right now, and it can be a little bit hard to get information, but there are resources for that. In Cuyahoga County, there's the Judge for Yourself website that is super. You probably are aware of that. It sounds like some people are nodding their heads. But think about state judges too. That's definitely something to pay attention to. State legislators getting involved in those, and it can be easier to have a vote in those cases. I mean, not to have a vote, to have a voice, right, with those folks, because their constituencies are smaller than like Senator Portman's constituency. That being said, I think always still call your senators, call your federal representatives, just call anyway. They need to hear it. The other thing, I mean, I think, you know, people feel different ways about this, but one thing, you know, like I mentioned, I'm very involved with preterm, and one way that preterm has tried to attack this issue is by kind of stigma busting. So taking away the stigma around abortion, given that, you know, 1 in 4 women, again, in their lifetime will make this decision, how common it is. Everybody probably knows someone, whether you know it or not, right, who's made this decision. Talking about it, you know, and not, I mean, you know, some people say, you know, there's a movement to kind of talk about your own abortion if you've had an abortion, you know, even if you don't like to do those kind of personal stories, that's fine. Just talking about it, just saying abortion, saying, you know, saying what you think about it is, I think it's just important to talk about it. Some people, I think, you know, some people identify as pro-life because they feel for them, personally, it's not the right decision, and so that means, you know, I'm pro-life if I would never do that. But, you know, the politically pro-life means that you think you should make the decision for everyone else too, right? And I don't think as many people are really in that space as pro-life politicians claim, right? And so I think just kind of having these conversations is really important, and just trying to break up the stigma around it. You know, returning to the idea that this is a very, as Mary was saying, this is a very private, personal decision that every person has to make for themselves. I think that's how we came so quickly in the gay rights world, right? From, you know, states where it couldn't pass laws fast enough to take rights away from same-sex couples, to a world where, you know, same-sex couples have this right to marry and have massive political support. The sort of stigma started to go away. People said, I have a cousin, I have a best friend, I have a kid with, you know, who's gay. And I think, you know, maybe we could do the same thing with abortion.
I thought that originally there were laws too about the process of having an abortion, that actually there had to be an appointment with the person who was having the abortion so that they totally understood what was going to happen, and to make sure that they were really understanding and still wanted that abortion.
Oh, yes, absolutely. Absolutely there are. So, Ohio, for example, I mean, and this is fairly typical, Ohio has a law that 24 hours before the procedure, you have to go go to the clinic, have in-person counseling, you have to be given various information that's specified by the state. You actually also have to, you have to have you don't have to have an ultrasound, but everybody gets an ultrasound. You have to have, as of 2013 or so, there's a law that says they have to check for the heartbeat, whether there's a fetal heartbeat, and you have to be told and given the opportunity to see or hear the heartbeat. And you have to be told whether, if you didn't have the abortion, what your likelihood of carrying the pregnancy all the way to term would be. So there's all kinds of information that has to be given, but also absolutely the part of the counseling process as well is that the woman's decision has to be voluntary, has to be informed. That is the whole point of the counseling that the clinics provide, and none of them would go forward with a procedure where the woman didn't want it. So you have to do that 24 hours ahead of time, then you have to come back to get the procedure itself the next day. So there's this waiting period and informed consent requirement in Ohio, which, like I said, is fairly typical except for that heartbeat thing, which is a little weird, but yeah.
Thank you.
Yeah.
2 questions. Do we, over here,
Oh,
the short
sorry.
person over here,
Yeah.
could you talk a little bit about contraception and where that fits into this, and also give us a more global picture? Where does our country stand compared to the rest of the world in abortion?
Both great questions. With respect to contraception, one of the great ironies is that a lot of the folks who are in favor of restricting abortion access are also in favor of restricting contraceptive access. And, the main way we've been seeing that lately, I guess, is by, I'm sure you've all heard of the controversy over the Hobby Lobby case from a few years ago and rules around giving employers authority to opt out of providing insurance coverage for contraception to their employees, even though that's required under federal law, under the Affordable Care Act. To some extent, there have been other kinds of conscience protections as well that affect abortion access, like, certain, trying to expand laws that allow healthcare providers not to provide contraception as well as abortion and things like that. But most of it has been around these employer opt-outs that the current administration has tried to expand. Right now there's a rule, I think it's not in effect because it's been tied up in litigation, but there's a federal rule that would allow any employer just to decline to cover contraception in their insurance plans, either based on a religious objection to it or a moral objection to it. So just extremely, extremely broad, which is problematic. I mean, I think, I guess the other way in which contraceptive access is kind of being affected by this whole debate around abortion is that, and what was really at issue at Hobby Lobby was that some individuals, based on their religious beliefs, think that certain contraceptive forms are actually abortifacients, are actually causing abortion. Because they are claimed to have an effect on the egg after it is fertilized. And my understanding is the science on that is actually not at all clear. But they define certain contraception like IUDs and emergency contraception as abortion. And so if we start to see this patchwork where, abortion might be totally illegal or only legal under certain circumstances in the US, we could see that impact on at least certain forms of contraception as well, depending on how abortion is defined. So that's a major point of concern too. Regarding the global picture, just briefly, it's actually kind of complicated. So, depending on where you look, in Canada, my understanding is that abortion has been decriminalized. It's there's actually technically not a lot of legal regulation, but I gather that there is a right to life movement in Canada that is also making some noise, and some people feel like it's under threat there. I think access to medication abortion is actually more restricted in Canada than it is here, oddly. In sort of Western Europe, the other countries that we tend to look at, again, you know, it's a mixed bag, but I would say by and large, most countries in Western Europe actually cut off the right to abortion earlier than in the US, somewhere around 15, 16 weeks, but at the same time, they make access to early abortion much more widespread. Like in France, for example, I think you only have the right to until 13 weeks, 15 weeks, something like that. But, you know, National Health Service pays for it. You can get it from any doctor. So the access is much better. In Germany, it's a very strange situation where it's actually technically illegal, but they don't prosecute it. And so the woman has to go for state-mandated counseling, but if she goes through that step, then she's free to make the decision, you know, for herself. So it's a very, you know, every state kind of, or every country does kind of handle it quite differently. But I would say in general, at least in most, you know, liberal democracies, there's better access, even if some of the laws are more restrictive in some ways.
This is more a statement than a question, but back before abortion was legal in Ohio in the late 60s and early 70s, there were groups that went and gave panels on TV, radio. In Catholic churches, we were never asked to speak in a fundamentalist Christian church, but so there were a lot more panels with both sides presented. Then I don't see any of that going on now, and maybe it's time to start that again. You mentioned also the people need to talk about their experiences, and which is true.
Thank you.
Just a response, first of all, to your statement. In 1969, in Los Angeles County University, Southern California Medical Center, as an intern, I did 100 abortions on the incomplete miscarriage service. In 1969, it was estimated there were 800,000 abortions done in the United States, so it was a very active process. And what fueled my interest in this is, and one of the reasons I'm here, is that I saw two women during that 2 weeks, both teenagers, come from Mexicali and who died of sepsis secondary to their abortion. So there were illegal abortions going on then, but there were also well-done abortions being in that LA County, of course, county hospital. My question really is to see what you might think about the future in Ohio. Unfortunately, and I'm sure this audience shares my that, is that there's a good chance DeWine will win the election. If he does, and Dettelbach loses the Attorney General slot, and the assumption is the legislature will stay Republican, what is your, and we all know what DeWine's behavior has been as Attorney General, filing briefs all over the country against just about any aspect of women's rights, and if I'm correct, I think he's anti-birth control as well. What is your prediction as a lawyer about what Ohio is going to face as DeWine wins and Dettelbach loses?
Yeah, thank you. That's a good question. And actually, I will say, even if Cordray wins, so what's been going on specifically in Ohio is the legislature has taken a little break from restricting abortion rights because of the election coming up, and so things have been relatively quiet. We fully expect either way after the election, if Cordray wins and then there's a lame duck legislative session, that's actually likely to be worse because they're going to cram a bunch of stuff through before Cordray gets into office. And even if Cordray wins, there's likely to be, probably a veto-proof Republican majority in the Ohio General Assembly. But right, if DeWine wins, they may take their time a little more. But I can tell you there are bills already in the pipeline that will there's probably gonna pass either way, whoever wins. So one is, a restriction, a ban on the most common second trimester, procedure for abortions, which would essentially, the impact of banning this particular procedure would mean that, abortions can only be performed in clinics up until about 16 weeks of pregnancy. So after that, you would have to go to a hospital, and most people can't go to hospitals for abortions because they don't have insurance that's going to cover that, and it's insanely expensive, as you know, for anything if you're paying out of pocket to go to hospital. So essentially cutting, and a lot of hospitals don't even do elective, so-called elective abortions. Essentially cutting off the right to abortion at 16 weeks in Ohio. There's another law in the pipeline that would require fetal tissue from an abortion to be buried or cremated. Those are the only methods of disposition for that tissue. So, and this is kind of crazy. I mean, the way the law is written, it's so crazy. And it says that, and this is individually. So even if you have sort of like an 8-week pregnancy, you don't even know, you have to, the funeral homes don't even know what to do with that. Like, they don't even know, like, they don't do that, right? I mean, it's one thing to say, okay, a later pregnancy that ends for whatever reason, you have a fetus, and you have, that actually at 20 weeks, it's already the case, 20 weeks or later, whether it's a stillbirth or a termination, that you have to issue a burial permit, and the fetus can be buried if the woman chooses. But this would go to 4 weeks or something. So yeah, and but it's also prohibited, would be prohibitively expensive, likely, because it has to be each one individually buried or cremated. And not incinerated like other medical tissue, but actually cremated. So those two laws are almost certainly gonna pass. There's another run at this so-called heartbeat bill, which was vetoed by Governor Kasich several years ago, but it keeps getting reintroduced. That would ban abortion as soon as a heartbeat can be detected, which is about 6 weeks of pregnancy. And then there is this completely off the wall proposal to define basically a fetus or embryo as a person under Ohio law for all purposes, including the murder laws and manslaughter laws, and that would basically criminalize abortion under all circumstances, and make everybody liable for going to prison, like the woman herself as well as the doctor. That I really don't think is likely to go anywhere right away, even if we have a Republican, net pickup in seats, and even if DeWine wins. It's a very, very extreme law. But the fact that that's even kicking around is pretty scary. So it's only going to get worse. And the other thing that, not to underestimate, the governor appoints also the director of the Department of Health in Ohio, and the Department of Health regulates clinics, abortion clinics, and can make their lives really miserable too if there's a hostile regime, and they have done that a little bit, and I think that will only get worse too if a Republican wins the governorship. So not good. Yeah, and I just wanted to pick up on something that was just said before that too. Just to point out the point about before Roe v. Wade. Sorry. Before Roe v. Wade, the statistics you read say that the abortion rate was about the same as after, which I always find that astonishing. I just keep thinking it can't be right, but I've read it in numerous places, and in reliable sources. So, and we're seeing essentially pre-Roe type conditions now in some places as well. So it's become very common in certain parts of Texas where there's very poor access for women to be buying abortion pills from Mexico. Apparently they're on sale in the flea markets there in southern Texas, and there has been some reporting of an uptick in sort of self-abortion, people seeing women who have tried to self-abort because of the lack of access.
My question is about the medical community's role during the passing of such legislation. How important is it? What can we do to require basically science to have a seat in the table during the passing of such legislation?
That's also a great question. I mean, I think that has been one of the under-recognized stories of what's happened since Roe v. Wade. When there was the initial movement to decriminalize abortion, there was this very intentional idea that we want it to occur in these freestanding clinics and not be under the kind of control of hospitals and hospital hierarchy, and it'll be less expensive if it's in clinics, it'll be more less restricted if it's in clinics. But what's happened is that abortion has kind of become like ghettoized within medicine, right? So it has become very separate. Like, I think a lot of doctors, if they do abortion, they do, not all of them, and actually it's not true necessarily in Cleveland, but a lot of doctors, if they do abortion, they only do abortion. And if they are OBs and they practice in hospitals, they do everything but abortions, or they'll only do abortions in certain circumstances, right? And so there isn't this, so I think, we do have doctors who will go down to the Ohio General Assembly and testify against some of these laws, and if you're, or anyone here is interested in ever doing that, I can put you in touch with people who would love to have you do it. And so there is definitely an opportunity to do that. But I think that the more broader mainstream medical organizations have not been as vocal against these sorts of laws, like the AMA, for example, as they could be. And I think, getting active with your local affiliate of your medical, if you are a doctor, of your organization, and expressing that you want them to take a position on these laws would be great. Or just take a position on, on scientific accuracy, medical accuracy in legislation, right? And kind of recognizing that these sorts of laws, affect, all doctors should be angry about these sorts of laws. Ohio in 2004 was the first state to pass a law restricting the way medication abortion could be prescribed, the medicine could be prescribed. And it told doctors what dosage they had to use of the drug and how, up until what point of pregnancy they could prescribe this. And this was basically to make the medication less available and to make it more expensive. I mean, can you imagine any other field of medicine where the legislature tells you what dosage to prescribe of a drug? I mean, these folks are not doctors. I don't know if any of them are doctors, And to think that, everybody should be up in arms that the legislature is going to regulate doctors who, with their training and their medical school and their fellowships and everything in that way is really, really offensive. And yet, like, nobody was there. Nobody was writing about it. Nobody was complaining about it, outside of the doctors who were immediately affected. And we have to get the word out too, of course.
Yeah, I was wondering, should the Democrats take over the House and the Senate, what kind of chance would we have to overturn Cavanaugh, impeach him, or whatever that is?
Right. I would not be surprised. I don't know. I'm not really a political insider in that way, but I wouldn't be surprised if there were at least investigations. If the Democrats take over either house of Congress, I think. However, to impeach him requires the majority of the House and 2/3 of the Senate to actually remove him. So that seems like a really remote prospect. It's I don't think it's ever happened that a justice has actually been removed through the impeachment process, although there's been one impeachment of a Supreme Court justice. So I don't think the prospects are great. I don't think the prospects are great. I don't know, that would certainly help with lower federal court judges if we could take back the Senate. If the Democrats could take back the Senate. That seems like the least likely scenario too. So, and it's only the Senate that gets a say on federal judges, not the House. So. It's grim.
Can you explain why the Establishment Clause, religious freedom, has never been used as a basis for protecting reproductive rights?
Yes, that's a good question. So the Establishment Clause is the one that says that there's, you have to have separation of church and state. And then there's also the Free Exercise Clause that says that individuals have a right to exercise their own religion. And the Establishment Clause, this has been tried legally, that the lawyers have made the argument that abortion restrictions are based in religious belief, and that it's basically the state, adopting a religious belief and rationale for its laws. And the Supreme Court has just rejected that idea outright. They've said there are plenty of non-religious people who are opposed to abortion for non-religious reasons. You can have just moral reasons for being opposed. And just because a particular viewpoint lines up with religious beliefs doesn't mean that it's inherently religious. So, we have laws against murder. All religions also, believe that murder is religiously wrong, morally wrong. But that doesn't make murder laws unconstitutional somehow. That's basically the court's view. And it is complicated, right? Because so much of our law is wrapped up with essentially Christian ways of thinking, or I guess not speaking for all Christians, but the sort of traditionalist Christian viewpoints on law. So there's a lot of complexity there. The other thing that's been tried is some folks have said, well, my religion doesn't say that life begins at conception. My religion says, really the fetus doesn't have any independent moral status until birth, for example. Why doesn't that matter? And the problem there is that, that's really a free exercise claim. That's a claim about how I should be able to practice my religion. And the courts, it's really hard to win that kind of argument because that may be true, but most religions don't require you to perform an abortion. They may allow you to, but you really need to say the law is conflicting with an actual requirement of my religion in order to win one of those cases. There may be there may be room for an argument like that in some cases, and I would love to see it, where somebody says, my religion tells me I have to help a woman who's in need and distress if I'm capable of it, right? And I don't think that that's a frivolous argument, but I haven't seen it yet. I think that's the only place you could kind of make the argument. If you can make a claim that your religion requires you to do this, which again, maybe it does in some circumstances. And maybe we'll see that, actually. I think, if we start seeing actual bans, maybe we will see arguments like that. Maybe that's a way around Roe.
Hi, so I have a different kind of question. I'm a social worker, and I don't currently, but in the past I've worked in child welfare in West Virginia, and I know that they are looking at a lawsuit from the federal attorney general about not providing adequate foster care homes. So what kind of conversation has happened surrounding the burden that limiting reproductive rights for women, both contraception and legal abortions, are going to have on state agencies like anything related to child welfare, support for single unwed mothers? Is there any kind of conversation going on that? Because that's going to be ridiculously expensive.
Yeah. So no. We don't hear a lot of that is because it's hard to frame that argument because it starts to sound like a very utilitarian argument, like we should enable abortion because, for financial reasons or something, right? So we should let people, not, choose not to parent because it's expensive to raise. Like, it starts to sound like you're putting a dollar value on life or something, right? And I know that's not what it means, but it's very hard to kind of say it in a way that doesn't sound like that. I think, there was a study that came out, I remember 10 or 15 years ago, where somebody had determined that the drop in violent crime or in crime rates in America coincided with about 18 to 25 years after Roe v. Wade was decided, and there was this kind of, who knows what to make of something like that. It's too hard, but there was a suggestion that maybe, not having as many unwanted pregnancies leads to a drop in the crime rate because, the parenting is better and people's lives are better, people are not as poor, all of that stuff, right? But pro-choice groups kind of didn't really know what to do with that because it's sort of uncomfortable to sound like you're saying, it sounds like, eugenics or something to say that, right? Like we don't want to have more poor kids. And that's not, you're not saying we'll get rid of them, but it's a very hard conversation, I think, to have. But my personal view is, yeah, it's a big problem. The biggest impact and again, there was a recent study showing this, that one of the biggest impacts of denying women abortions who are seeking abortions but they can't get them for whatever reason, because of problems with access, financial reasons, whatever, is it makes them poorer. It just makes people poorer, almost universally. And that's, I think that's a very important thing that gets lost in the discussion.
We have time for one more short question.
Since 1973, we've had a complete revolution in how people get information and how people acquire goods. Could you address the legal implications of distance medicine and people getting things over the internet from state to state or within the state?
Yeah, that's actually a really big topic, so I'll just try to say a couple of things. I mean, right, there's been an explosion in telemedicine in a lot of places, including Ohio. That's probably the other thing that we can expect coming down. I should have mentioned it before. If in the next legislative session might be restrictions on that with respect to abortion. We've seen it starting to happen in other states, because it is possible, especially for medication abortion early in pregnancy, to do it by telemedicine very easily. And so, and that does exist in some places, but it's, again, it's another battleground. Internet, I mean, I've heard of people buying the medication abortion drug over the internet. You can get it from other countries, you can get it, online. It's not really a good idea, just like any sort of medication that's unregulated, right? It's not, but we are starting to see a lot more of that. And I think just the fact of having this medication option does have the potential, but we've been saying it was approved in 2000 in the US, and we've been saying since then, it has really the potential to revolutionize abortion, and it hasn't yet. But I think you're right that we're getting to this point where technology and the medication are kind of starting to coincide, so it might make a big difference.
Thank you, Dr. Hill. Here with one more question.
Oh, okay, sure.
Okay, the question is really, you've talked about reproductive justice in terms of for what the impact of becoming more poor and the economic. What are some of the other reproductive justice issues besides poverty and economy?
Well, I mean, I think so. The idea of reproductive justice is the idea that it's not just about abortion rights per se. That reproductive justice means empowering women to decide whether to have a child, when to have a child, and under what circumstances, to have a child. To make sure that if you want to have a child, you can raise a child, safely and and expect the child to survive, right? So, infant mortality, for example, is a big racial justice issue, I think, or a reproductive justice issue, which is also a racial justice issue, right? And that's the other dimension of reproductive justice, is that, the people who are disproportionately not having those opportunities to make those decisions freely are poor women and otherwise marginalized women, minority women, women who are, under state control in various ways. Yeah, I mean, but it's a much broader way of thinking about it. I mean, you could think about even, climate change as being a reproductive justice issue in some ways, right? So that if we don't have a world that's livable to give to our children, then we're not really being enabled to bear children in a meaningful way, or to parent in a meaningful way. So it's, and also, I mean, I could sit here and talk for a whole, half hour again about the condition of women who are incarcerated, for example, or in state detention, and their access to reproductive health care of all kinds. I mean, even like menstrual care, it's atrocious. It's a story that, again, should be told a lot more than it is. So kind of thinking about the broader picture in all sorts of ways, and again, I'll come back. We can talk about it again.
Forum next week. Dr. Mark Snyderman will be here from the Case Western Reserve Weatherhead School of Management. He's a professor there, and he's also the former vice president of the Federal Reserve Bank.